4. Marriage and divorce. The author of The Family and Social Work says, "Our modern monogamous family represents the survival of religious, ethical, economic, and legal elements from all the intermingling streams which unite to make the civilization of which it is a part. Hebrew, Roman, Teuton, and others more remote have made their contribution." Recent writers stress the importance of the family in a different way. People do not marry because it is their social duty to perpetuate the institution of the family, or because the preacher and Mrs. Grundy both recommend matrimony, or even because they fall in love with each other. They marry because they lived in a family as children and still cannot get over the feeling that being in a family is the only proper, indeed the only possible, way to live. The normal conventional family starts with marriage, but the history of this institution shows that it has taken centuries to develop to its present rank in the social order. In the early stages of civilization, marriage by capture was a favorite method and, as we know, was practiced by the Romans. In many countries, marriage was not confined to the union of one man and one woman, and polyandry and polygamy were the usual practices. If we agree that the family is the fundamental unit of society and one of the fine developments of civilization, we should then examine its status, obligations, and duties from a legal standpoint. Marriage, a contractual relationship. Marriage is commonly said to be a civil contract, but more truly the betrothal or engagement leading up to the marriage is the contract. The marriage grows out of this, and when consummated by the legal ceremony and the parties become man and wife, it establishes a legal status which imposes certain rights and privileges as well as obligations. It resembles other contracts because the parties who wish to enter the marriage relation must be legally competent. There must be mutual consent, and the marriage must be in the form prescribed by law. Unlike ordinary contracts, which can be set aside if the parties wish, this one cannot be dissolved at the will of the parties because it is of public concern. Formerly, it was necessary for the legislature to grant dissolution, but now it is accomplished through the court by a divorce decree. There is another difference in the marriage contract. In practically all other instances, the parties must have reached the age of majority in order to make a binding contract, but a marriage contract can be made earlier. There are several limitations which the law places on those who wish to marry, such as that of age, of near relationship, and of previous marriage, even though there is mutual consent and solemnization in the prescribed manner. The age limitation. At common law, a female could marry at 12 and a male at 14. This is still the law unless changed by statute, but most states have fixed the minimum age, which may be from 14 to 16 for females and from 17 to 21 for males. Until very recent years, however, there were 11 states that permitted the marriage of females of 12 years, either by direct provision in the statutes or by lack of any statutory provision, so that the common law prevailed. In most states, the minimum age requirement may be waived if the parents consent to it and marriage seems expedient. Pregnancy is often considered a sufficient cause for the waiver, but the policy of granting a license for this reason has questionable value, though it seems to settle the problem for the moment, and does what so many people think desirable. It gives the baby a name. Social workers, however, know that the emotional wreckage following a marriage under these conditions may be very costly to the individual and to society, and it is often better for the mother to assume the responsibility alone. Criminal liability involved. The criminal factor is often involved, too, if the girl is under the age of consent, the age fixed by statute under which she is presumed to be too young to have consented to sexual intercourse. This age in most states is 16. Her pregnancy is therefore the result of a criminal act, for which the man is liable and can be prosecuted. If a marriage takes place, it will be a bar to the prosecution for the sex offense in most states. But marriage under these conditions does not provide a good foundation on which to build a satisfactory life. Void or voidable marriage and annulment. Though there may have been a ceremony, a legal marriage is not always established, and as a result the marriage may be void or voidable. If it is void, no marriage exists, but if it is voidable and the parties wish to have it set aside, legal action must be taken for annulment. Some of the causes which will render a marriage voidable are infancy, the use of force or duress, or fraud which amounts to a false representation, as the concealment of a disease or an untrue statement relating to pregnancy which is material to the marriage relation. In Massachusetts, court annulled a marriage on the proof that when the marriage took place, the man had a communicable disease. His wife was told of this a short time after the ceremony and before she lived with him, as this affected their marital relations, her health, and the health of any children that might be born. The marriage was annulled. A marriage under the statutory age is usually voidable, and not void even if the legal requirements are not met. For instance, if only the parents' consent is obtained when permission from the court is required also, as in New Hampshire. Such marriages as a practical matter are not avoided, for if the parents were willing for the marriage to take place, they clearly will not petition for annulment. One court has held that the parents did not have this right exclusively. A child of 13 years and 7 months was married in New York State, and when she was 16, as she had not lived with her husband, her father brought action to have the marriage declared void. The court said that the marriage contracts of infants are not dependent upon the parents' consent to the marriage, and the parents could not have the marriage annulled on that ground, and further added that it was only the infant wife who could bring the action for annulment. A very unfortunate situation may arise in a marriage under the statutory age, for if either party wishes to disaffirm the marriage when the minor becomes of age, it is possible to do so and claim that there was no legal marriage, and if there have been children, they are illegitimate. On the other hand, the Supreme Court of Ohio held the marriage for non-age invalid unless the parties lived together after arriving at the statutory age. As a rule, the courts recognize a legal presumption in favor of marriage because it seems the best public policy and gives protection to women and children. There must be mutual assent of the parties in order to constitute a marriage, and if both parties are in high spirits from imbibing and consider the matter a joke, even though there is a ceremony, no marriage exists because the intent is lacking. Also, extreme intoxication which will prevent intelligent action will render a marriage void or voidable, depending upon the statutes. In the absence of statute, according to Tiffany, such marriages are void, but usually by statute they are voidable only. Other impediments to marriage. Consanguinity. At common law, marriage within certain degrees of relationship was prohibited. The disqualifications of relationship were determined by the church, and the law as enacted in England during the reign of Henry VIII prohibited the marriage of those of nearer relationship than cousins. This ecclesiastical law is followed closely in every state today, and some states prohibit the marriage of first cousins. This prohibitory law was on the ground of the sanctity of the home and the protection of children. For as civilization has advanced, people have held incestuous marriage in abhorrence, though this was common among Egyptian people. In South Carolina, a man married his niece, a brother's daughter, and when he died, action was brought by his children of a former marriage to claim all of the estate on the ground that the marriage with the niece was void, and that she was not entitled to any of the estate. This court held that a marriage within the prohibited degrees of relationship was not void but voidable, and if not dissolved during the lifetime of the parties, conferred civil rights of marriage, such as the wife's right of dower in her husband's property. A New Hampshire decision was in direct opposition to this, for when two cousins married, the husband was denied any rights in his wife's property after her death because the statute in force at the time of the marriage prohibited the marriage of first cousins, declaring such a marriage void and the issue of the marriage illegitimate. Feeble-mindedness. Many states now have statutes prohibiting the marriage of feeble-minded persons, and sometimes there is a penalty attached for the one who issues a license to the same. This shows progress in the acknowledgement by public opinion that the state has the right to prohibit marriages which will perpetuate the unfit. However, some legal machinery is needed to aid the official in determining the mental status of the applicant before the law can be wholly effective in preventing such marriages. Some states require the registration of all feeble-minded persons, and this provides a basis for refusing the license. It is possible to bring an action to nullify such a marriage, and as long ago as 1850 there was a well-known case in New Hampshire. In this instance, a girl over 21 went into the state of Vermont and was secretly married to a man who probably knew that she had some property. In the petition for annulment, her father showed that she could not dress herself, and though she went to the district school until she was 20, she could not spell, add, and subtract, or tell the time of day. She could not learn to do housework, and had no idea of the time involved in getting a simple meal. She could neither distinguish colors, count beyond 20, nor do an errand. She was satisfied to play with toys and with children 4 or 5 years of age. It would not seem necessary that the court should be endowed with high intelligence in order to decide that she was entirely incapable of understanding the nature and obligations of marriage. Insanity. The question of the marriage of an insane person has never been well settled, and the degree of mental incapacity which will render a marriage invalid is still an open question, though it is settled that the mental disease must exist at the time of the marriage. Some authorities hold that insanity renders a marriage voidable, and not void if the person temporarily regains reason and affirms the marriage. In most states, insanity is not a sufficient ground for divorce, as it would be regarded as harsh for a man to put away his wife because she had become insane. But some types of insanity, being hereditary, go to the very root of the marriage relationship. Probably in time, when there is a better understanding and acknowledgement of mental ills, provision will be made for the protection of future generations through laws prohibiting marriage of the insane, and a greater number of states will grant divorce for this reason. Miscegenation. On the ground of public policy and for the protection of future generations. Miscegenation, or the intermarriage of persons of different races, as between Negroes and whites or Indians, and whites or Chinese and whites, is prohibited in some southern and western states. There is no prohibitory law in states where the population is largely white, as such legislation has probably never seemed necessary. In some states, such a marriage is not only prohibited but may be prosecuted as a crime. Prior marriages. Bigamous marriage has always been prohibited in Christian lands. It was originally an ecclesiastical offense, and its prohibition became a part of the common law. Bigamous marriages are usually held to be absolutely void, even though the parties acted in good faith and thought they were free to marry. Any marriage is illegal while a prior marriage is still in force, but if M marries A, and while she is still his wife he marries B, and after the death of A he marries C, the last marriage is not bigamous because the marriage to be was void, and upon the death of it he was free to marry. Bigamous marriage, however, brings us into the realm of criminal law. The common law marriage. In England, the common law marriage was recognized when two people showed by mutual consent a desire to assume the marriage relationship, living together as husband and wife and having that reputation in the community. No marriage ceremony was held necessary. Court decisions in this country have not been uniform with regard to common law marriages. Many states appear to recognize them, but a court decision may be contrary to the statutory provision, so it is almost impossible to be exact on this point. In Illinois, Mississippi, and New York, a common law marriage is definitely declared not valid. In Arizona, California, Connecticut, Kansas, Louisiana, Utah, Virginia, West Virginia, and Wisconsin affirm that a marriage cannot take place without a license. At any rate, there must be an intent of the parties to consider themselves married in the eyes of God, and it cannot be merely a casual arrangement nor an agreement to sexual intimacy following a promise of future marriage. This is an unlawful contract, as it is against public morals and is not recognized by the courts. In many states, the question of inheritance of property has been involved with the legality of a common law marriage. In a Minnesota case, a man who was supposed to be a bachelor died, leaving a will which he had made many years prior to his death. After the will was proved and probated, a former housekeeper of his came forward and stated that she was his wife and asked for the property to which she was entitled by law. To prove this, she produced a contract of marriage between a Hewlett and Mrs. Ella Pomeroy. Believing a marriage by contract to be perfectly lawful, we do hereby agree to be husband and wife, and to hereafter live together as such. This was signed and sealed by the parties. The court held that though the arrangement was secret and there was no reputation of their marriage in the community, their consent legally expressed made this a marriage, and she was entitled to the property. Statutory requirements. The marriage laws of the various states are not uniform, but in all jurisdictions there are statutory provisions which regulate the procedure. These regulations provide for the formalities of obtaining a license or of publishing bans and solemnizing the marriage. Each year, additional states require that a certificate showing that the parties are free from certain communicable diseases must accompany the application for the license. In order that the marriage may not be hasty, many states require an interval of a few days between the application and the granting of the license. The ceremony must be performed by a legally authorized person, either a magistrate, clergyman, priest, or rabbi. The provisions are usually directory instead of mandatory, and a marriage will not be invalid if all the formalities are not obeyed. The final step is the return of the license to the proper officials with the report that the marriage has taken place. This report then becomes a matter of public record and can be verified at any time. The law of the place of the marriage controls its validity. As with any other contract, the general rule is that a marriage is valid in any state if it is valid where it took place. Some states make an exception to this rule when there is an interlocutory decree of divorce which prohibits another marriage for a certain period of time, and there is a deliberate attempt by both parties to evade the law of the state of their domicile by going into another state in order to marry. Wisconsin, North Carolina, and Tennessee do not recognize this as a valid marriage nor the children of such union as legitimate, while Vermont, New York, and California hold that marriage is prohibited only in the state where the divorce was obtained, and that a marriage outside of that state, even though within the prohibited time, will be recognized in the state where the divorce was granted. This would seem to be a better rule when children are involved. A suit for breach of promise to marry. When there is an engagement or a contract to marry and one of the parties refuses to carry out the agreement, the other party can bring a suit for breach of promise. It is usually the woman who brings such a suit, and the agreement is proved by evidence which will show the conduct of the offending party. The only remedy is damages. The financial and social standing of the parties will be taken into consideration, and compensation may be awarded for the pain and injured feelings as well as for loss of time and expense in preparing for marriage. On the other hand, it may not be possible to show that the woman suffered any injury and then she cannot receive damages. Today, the trend is to discourage such suits. Divorce and separation. Probably no subject has been more generally discussed in recent years than divorce. Its various causes, especially those related to economic insecurity and sexual or emotional incompatibility, have been discussed freely in the press and literature of the day. How they all fit into the legal pigeonholes is another side of the situation. Kinds of divorce. Divorce is the legal separation of husband and wife by the judgment of a court. At common law, there were two kinds of divorce: a mensa e ahoro, or from bed and board, a qualified divorce which did not dissolve the marriage, and a tranquillo matrimon, or absolute divorce which dissolved the marriage. In some states, a legal separation similar to a divorce in mensa et thoro will be granted for certain causes which are not sufficient to justify an absolute divorce, or to couples who do not wish to live together but do not believe in divorce. The parties themselves may enter into an agreement to separate if the separation follows immediately, but they may not agree to separate in the future. The question of uniformity. Whether or not we agree with those people who think there should be uniform divorce laws for the entire country, the present situation is undoubtedly confusing. As long as the laws and interpretations regarding the grounds for divorce are different in the various states, a person may find divorce harder to obtain than is generally supposed. Because of this confusion, a person may be divorced in one state and still legally bound in another. This was true in a New York case which was finally decided by the United States Supreme Court, this court taking jurisdiction on an appeal, as the suit involved citizens of different states. The matrimonial domicile of the parties was New York. The husband abandoned his wife without just cause and established a new domicile in Connecticut, where he brought suit and obtained a divorce according to the laws of that state. His wife did not appear to contest the suit, but she later brought suit in New York and obtained a decree in alimony. The New York court held that under the law of New York, that court was not required to know or give effect to the decree of Connecticut. The Supreme Court so refused to require the state of New York to recognize the decree if the husband was guilty of wrongful abandonment. Most states, however, recognize the right of the parties to acquire a new domicile, which means that the court where the new domicile is acquired has jurisdiction and can grant a decree which other states will respect. In this particular case, after the Connecticut decree and before the New York decree, the man was single in Connecticut, while in New York he was still married to his first wife and could not lawfully marry a second time. Grounds for divorce. Adultery is the most common legal cause for divorce in all the states except South Carolina, which recognizes no ground for divorce, will grant it on proof of this allegation. In New York State, this is the only cause allowed, but in some other states, as many as 13 legal grounds for divorce are recognized. Many of these are closely linked together, and the principal ones are adultery, cruelty, desertion, and non-support, impotency, habitual drunkenness, conviction of a crime followed by imprisonment, and other miscellaneous causes are recognized less frequently. Adultery. Adultery is generally defined as the voluntary sexual intercourse of a married person with a person other than the offender's wife or husband. The various statutes may qualify this definition somewhat. Sometimes some party may suppose the other party to a marriage is dead and may marry, only to find out later that the supposition was untrue. In such a case, some courts consider that no adultery was committed, proceeding upon the theory that to constitute a ground for divorce, the same criminal intent is necessary that is required to constitute the crime of adultery or bigamy. The criminal intent is denied by the honest though untrue belief. If there is negligence in not getting the true facts, this will not be a defense, for it is looked upon as a mistake of law, and ignorance of the law is no excuse. When a woman was advised by a justice of the peace that she had obtained a divorce and could marry, again, while in fact the divorce was not legal, she was guilty of adultery when she lived with the one she supposed was her second husband. Cruelty. The statutes recognize three types of cruelty. They are cruelty, extreme cruelty, and extreme and repeated cruelty. To constitute cruelty, there must be an infliction or threatened infliction of bodily harm, or words or conduct that cause great mental suffering and thereby injure or threaten to injure the health. Formerly, the decisions largely upheld the opinion that there must be physical violence, either actual or threatened, and that mental suffering such as would be caused by a husband accusing his wife of infidelity before their adopted son would not constitute cruelty. Courts of many states now recognize that great mental suffering affects the bodily health and have granted divorce for that as well as for physical cruelty. Desertion. The statutory period of time which must elapse before a divorce can be obtained on the grounds of desertion varies from 1 to 5 years. To constitute desertion, there must be an actual cessation of cohabitation for the entire statutory period. There must be an intent to desert without the consent of the other party, and there must be no misconduct which would justify the abandonment. Probably wives are deserted more often than husbands, even though the law recognizes the husband's right to pick out the domicile, and the wife's duty to follow her husband. If she fails to do so, she is guilty of desertion. Refusal to immigrate from England to America was considered desertion by one court, but an Illinois court decreed that failure to live in the home of a mother-in-law was not desertion. A separation for business reasons or illness will not constitute desertion, but if after being apart for some time one party develops an intent to desert, the required statutory period will date from the time the intent is formed. An offer to return to the domicile of the husband or wife within the required period will bar desertion as a ground for divorce. A husband is not obliged to support his wife away from his domicile, but if his conduct is such that she is driven away and he is able but does not support her, this amounts to desertion. According to decisions in several states, it makes no difference whether the husband deserts his wife or so conducts himself that she is forced to leave him. Non-support. Some statutes combine non-support and desertion, but non-supportal one may be a ground for divorce. Non-support is a relative condition, and the court will take into consideration the station in life of the parties. The person, usually the wife, is entitled to sufficient support to enable her to live according to the standard of life to which she is accustomed. This includes such necessities as food and clothing, and may even include jewels and furniture. If the husband is not able to support his wife, a divorce will not be granted for non-support, according to a decision in Texas. Habitual drunkenness. In order to obtain a divorce for drunkenness, this must be confirmed, and habitual, merely occasional imbibing is not enough. Conviction of a crime. Conviction of a crime which amounts to a felony and is followed by a sentence to the state prison for 2 years or more is a ground for divorce in some states. There has been some question as to whether a pardon would destroy the right of divorce action, but the general rule is that it does not, and this is expressly stated in the statutes of some states. A few states even provide by statute that the conviction of certain crimes shall work a dissolution of the marriage without legal process. Wide provisions for divorce. Public sentiment increasingly concurs in the belief that if two people cannot get along together, their marriage should be dissolved. And some states have made sweeping provisions for divorce for any reason which has made married life a failure. Some people even go so far as to advocate that if mutual consent is necessary to bring about a marriage, it should work just as well the other way. And if two people have agreed that they cannot get along together, it should be possible to bring about a dissolution without going to court and proving serious charges against the other person. In many cases, these charges are not true, but the accused person does not contest them because he wishes the divorce to be granted. Judges have broad powers of discretion, but the belief in the sanctity of the home and the desire to save it if possible is still a strong consideration. It is a grave question whether or not a home which is kept together contrary to the wishes of the parties is worth saving, as continual discord may be more harmful to the husband and wife, and produce a more serious effect on children than a divorce. Defenses which are a bar to divorce. There are several defenses which may be set up to bar divorce. For instance, if a husband, either openly or by passive conduct, encourages his wife to transgress, he cannot later set up her infidelity as a cause for divorce. For in legal parlance, this is connivance. The parties may not combine to procure a divorce by some false practice, such as one of them doing or appearing to do what would otherwise be grounds for divorce. That would be practicing deceit upon the court and is called collusion. Condonation means to excuse or forgive, and legal condonation is the pardon of an act which would be grounds for divorce while the parties continue to live as if this had not occurred. The offense must cease, however, for the law does not require forgiveness of repeated acts. Recrimination will prevent both parties from obtaining a divorce. For instance, if the husband sets up adultery as an allegation and the wife charges him with cruelty in non-support, and both are proved, neither party can have a divorce, for the court will believe that they are both at fault and will leave them as it finds them. A case in point involved the following facts. A man brought action to obtain a divorce from his wife on the ground that she had deserted him for 5 years. She proved in defense that before the lapse of 5 years she married another woman and lived with her. This was sufficient to prove adultery on his part, and the divorce was not granted. Results of divorce. If a divorce is necessary, it is best to consult a good lawyer who will see that the client's rights are protected in every way. The custody of children, property rights, and alimony are all of great moment and should be settled at the time of the divorce. Usually, very young children are awarded to the custody of the mother unless she is an improper person to care for them. Later, the case may be reopened to further consider this one point if a change in custody is desired, as it then becomes definitely a question of the welfare of the children. The judge should have all the facts available at the time, and often a social worker can be of great assistance in getting this information. Courts do not always make a decree relative to the children, and the custody is settled between the parents themselves. This is an unfortunate practice and one that is fraught with future difficulties, particularly if neither parent is able to support the children and they become public charges. For if there is no legal custody, the question of settlement is sometimes hard to determine.